All right, let's go to the next slide. So, the legal toolkit, what are some of the different things that we work with clients? So, sometimes clients come to me, I need a trust. Um, what I tried, and maybe they do, but maybe they don't. So, it's really stepping back. What are the big picture issues that my clients are worried about? What's going to happen if I become sick? Who's going to make decisions for me? What will those decisions be? How are my assets going to pass? I'm worried I've got to take care of I have a disabled child. And I have this toolkit of documents that I can pick and choose for my clients of which are going to help them meet their needs. So, power of attorney, healthcare proxy, medical directives, sometimes guardianship, wills, probate, trusts, a care committee agreement. There are others, but these are among the ones that come up most frequently for my older clients. Next slide, please. So, starting with, there's a category of documents that we commonly refer to as advanced directives, um, durable powers of attorney, healthcare proxies, and a medical directive. And by advanced directives, you're thinking ahead of time who is going to be your decision maker and what kinds of decisions do you want them to make. These documents allow you to put that in writing and legally designate who you are empowering to be your agent in different areas. Next slide. So let's start with a durable power of attorney. This is a document where you are naming someone, we call them your agent, to make financial and legal decisions on your behalf in the event of incapacity. One question I'm often asked is, what does durable mean? Um, in this context, it means that the document remains effective regardless of your future incapacity. Now, that sounds kind of strange because that's when you actually need it. Why does there need to be some language specifically in there clarifying that? I don't know why, but if you don't have any language that says that explicitly, and it's therefore not durable, it'll stop being effective when you become incapacitated. There are two other categories, assuming it's durable, there are two other categories of powers of attorney. One we refer to as an immediate power of attorney. And by that, I mean it's effective the day it's signed. Now, what I often have to clarify for clients is that doesn't mean you're giving up control on the day you sign it. It just means that the person is now empowered to act as of the day that it's been signed. They are um, they have an obligation, however, to only act if they are directed to do something by you, or if they reasonably believe that you're incapacitated, and then they can begin serving in that role. A springing power is one that springs into effect upon a contingency happening. Typically, that contingency would be something like my doctor in writing stating that I am no longer able to manage my financial affairs. Now, on one level, that sounds better because it's more clear. However, I rarely write up a springing power because banks and other financial institutions, to start with, are a bit skittish and don't love powers of attorney because, if I'm power of attorney for my mother and I'm going to show up at her bank, they've never laid eyes on me, and I'm going to all of a sudden assert that I'm in charge of my mom's money, that is something that might make them a little nervous. If on top of that, I'm telling them I'm only power of attorney if my mother's doctor has deemed her to be incapacitated, that's something else they need to verify. So I typically just write an immediate power of attorney. Powers of attorney only stay in effect while you're alive. The person's death ends the power of attorney. You also can change your mind. You could revoke it if you decide someone's no longer appropriate for that role. The most important thing, I believe, in thinking about a power of attorney is who are you going to choose to be in that role? Now, when you think about what a power of attorney can do, you're basically giving someone the power to sign your name on your behalf regarding anything financial and legal, from a check to a tax return to the deed to your house. So it's an incredibly powerful document. And if it's exercised at a time when you're incapacitated, you're vulnerable. So, inherent in this document is trusting the person that you're appointing. Is this someone who you have total faith in that they will act appropriately? In addition, beyond trust, do you think they're capable? So, if your son, if his own financial affairs are a mess, he's had bankruptcies, he is not in good shape financially. He's borrowing money. Um, and your daughter is an accountant and gone to business school and, you know, couldn't be more um, astute regarding financial matters. You're going to appoint your daughter and not your son. And so sometimes my clients are worried they don't want to hurt someone's feelings. They feel like there would be a slight if they choose one or another. So you got to put that kind of thing aside and really think about who is most appropriate. Um, you also you can name multiple agents, so you could name your son and your daughter. If you're going to do that, you want to be sure you name them jointly and severally so that they don't have to sign everything together. My personal preference is to name one child or one person and then a successor to them. And my reason in that is if you name two people and they disagree, you'll they'll have to go to court to resolve it. So I think it's marginally better to name one person and then a successor. My only ever other caveat on that is if you are naming your spouse and your sister as a successor, that's fine, unless your spouse is also in their mid 80s and your sister is 92, then that's not the best choice. So, in thinking about a successor, they need to be younger enough that there's a good chance they'll be available when and if you need someone. I have some clients who don't have family, or they don't have family they can put into this role for all the reasons our families might struggle or have dysfunction, or just that there are lots of people who never had kids and aren't partnered. And so those clients sometimes choose a professional. Um, the downside to that is typically, the cost. It can be expensive to have a professional, whether that's an accountant or a lawyer in this role. But for some people who can afford it, it's a good alternative. Um, when people are appointed, they're often concerned, am I taking on any liability? My brother asked me to be his power of attorney. What does that mean? You don't have any liability. You're not taking on an obligation to pay their debts. You're not responsible for their own, financial obligations. Your only liability comes up if you obviously do something inappropriate. So stealing from the person, um, making irresponsible investment decisions, taking all their money and putting it into one risky stock, commingling of funds, that kind of thing. So anything that a reasonable person would do, you're fine. But something really egregious or negligence, you could have liability. Um, when I'm writing up a power of attorney, I write it very broadly. You want to cover everything, but I also lay out very specifically. There's a paragraph about insurance, there's a paragraph about real estate, about the IRS. So you want to, any situation where you think it might need to be addressed, you you want to make sure that's in there. Um, Sometimes, because financial institutions can be finicky about these things, I suggest that in addition to my power of attorney, clients sign a power of attorney specific to that institution. So, Fidelity or Bank of America might have their own form, and you could sign that as well, just to make things a little bit easier for you when you need to take over. The other question that I'm asked is, well, when, how do I know when to take over? So it's kind of a standard of like, certainly, if your parent or the person's aging and they don't want to be dealing with paying bills anymore, they could ask you to step in. But otherwise, if you're really seeing that the person is not able to manage things, that's when you can reasonably step in. And that can be kind of hard because you want to respect the person's independence. And in some situations, despite having a power of attorney, if the person is declining and impaired and you see that they're putting themselves at risk financially, if they're not willing to accept your help despite there being a power of attorney, you might need to go to court and become a conservator. So having it um, uh, having the power of attorney sometimes isn't enough despite everyone's best intentions. Often, and I'll talk about this a little bit later, it's a good idea to have a trust, uh, either instead or more typically in addition to a power of attorney. So that's about it on powers of attorney. I don't know if there's anything, Barbara, that you wanted to ask, but otherwise we'll move on to healthcare proxies. We can advance that slide. Sarah, can you well, I'm going to start while we're waiting on that. I'm going to start talking about healthcare proxies. There we go. So, healthcare proxy is sort of the other side of this advanced directive coin, where the power of attorney, you were naming someone to make financial decisions for you. On the healthcare proxy, you're naming someone to make medical decisions for you. Again, in choosing someone, it's important to trust them, that they will be able to make the decisions that you want. I think, unlike a power of attorney, it's probably better to have the person be close by. Proximity is something to consider if they're going to be the person taking you to doctor's appointments. And it doesn't have to be that way. Obviously, we communicate all different kinds of ways these days, but I think that, being a child who's nearby versus someone across the country, all other things considered, that's an important factor. Um, in Massachusetts, under our state law, you name one person at a time. Again, it's important to have a successor as well, so that you know if the first person's not available, there's someone else who can be called. Now, one important difference on the healthcare proxy and power of attorney, a healthcare proxy under our state law cannot be immediately effective. A healthcare proxy is not effective until the attending physician has invoked the proxy. So until your doctor in writing in the medical record says you're not able to make medical decisions, the patient makes decisions for themselves. So you need to have that official invocation, and then the agent is the person to make those decisions. Just like with a power of attorney, it's incredibly important to communicate with the person you're appointing. They need to know how you feel about all the different kinds of decisions you would want. And we can do that both in speaking with them and in writing. Um, One other thing I would mention in choosing someone, the person who you're appointing as your power of attorney, um, and the skill sets you're thinking about for who's appropriate, it could be different than the person who you need as a healthcare proxy. So, certainly it doesn't matter whether the person is organized and good with money, um, for a healthcare proxy. I think for a healthcare proxy, you're looking for someone who can be a good advocate for you. So, in our medical system, for better or worse, you really need to speak up and advocate for yourself and to get the care that you need. And sometimes professionals can help with that, but often we have to do that for ourselves. And so you want someone who's going to be able to ask good questions and speak up and demand the care that you need. Um, so if someone's not comfortable in that kind of a role, they might not be the best person. People often think about a healthcare proxy just in relation to end of life decisions. And that happens sometimes. So, clients will jokingly speak of pulling the plug and who's going to be the person who's going to make those decisions. But first of all, that doesn't happen that often. And really, it's more about advocating for you in different medical situations and hospitalization. So I think think about that when you're considering who to choose. Um, you still, under our state law and case law, if you, if even if the healthcare proxy has been invoked, if you are refusing a treatment, that's taken as a partial revocation of the healthcare proxy. So if you are saying you don't want a medication or you want to be discharged, um, that healthcare proxy might need to be um, brought into court for a judge to rule that it is in effect. Um, and that partly depends on the provider on how that's handled. But in general, the patient's refusal of a certain kind of treatment or care is taken as a partial revocation. We usually recommend that you give a copy of your healthcare proxy to your doctor so it's in your medical file. Um, it's important to think about how your healthcare agent will communicate with your power of attorney. So, what I mean by that is if you're naming one child as your power of attorney and another as your healthcare agent, and they have a poor relationship and aren't able to work together, that could really be a problem because the healthcare agent might be thinking mom needs home care, and that's the most appropriate place for her to be. But if the power of attorney doesn't want to pay for that, you might have a problem and the healthcare proxy might not be able to make the decisions regarding care that they would otherwise want to make. Um, Although the healthcare proxy has authority under our HIPAA statute, which is the medical privacy statute, I usually recommend a separate HIPAA authorization for two reasons. One, the healthcare proxy is not in effect until it's invoked, and you might want to give certain people the authority to speak with your medical provider directly. And secondly, in the proxy, you're naming one person who's the decision maker, but you might have a larger group. So one of your children might be your proxy, but you might have two children and a friend who you want to be able to speak to medical providers directly. So I have them for my clients as a separate document. Let's go to the next slide. Um, so beyond the healthcare proxy, I usually include in that document I would refer to as a medical directive. So medical directives and living wills are your written statement about what kinds of treatment you would or would not want. So, a living will or medical directive is evidence of your wishes. It doesn't have the same kind of authority that a healthcare proxy does. So, the healthcare proxy is the primary document. My personal preference is to have the directive in the healthcare proxy rather than a separate will, but there are lots of good living will forms out there. The Five Wishes, there's a website, Conversations with Caregivers, or the Conversation Project, excuse me, that you can go to and download information about, and forms to create your own living will. So it's your opportunity to really have in writing what your wishes are. In my personal medical directives in the proxy, it's very general language trying to capture the client's wishes regarding treatment. That general language could be applied in any situation. I also, in my living will medical directives, like to include language about incapacity. So, sometimes it might just be if I'm in a permanent vegetative state or permanent coma, I don't want intrusive medical procedures used to extend my life. But you could have another scenario if I have advanced dementia and I don't recognize my family members nor know who I am. I would not want to have intrusive medical procedures keep me alive, or I may not even want antibiotics to be used in case of pneumonia. So there's all kinds of things that you could include in there in terms of guidance related to dementia. You could include language regarding nutrition and hydration and comfort care. In addition, clients often are thinking about a DNR or a DNH, do not resuscitate or do not hospitalize, do not intubate. Um, there's a separate form that is called a physician's order for life sustaining treatment, a POLST form. In Massachusetts, we call it a MOLST, MOLST. And this is taking a DNR or a DNH and putting it in the form of a physician's medical order that is in your file. And so for some clients who feel that's important, that's a good thing to have, and it's a good idea to discuss it with your physician. Um, and the more of this stuff that you have completed, the more likely you are to have your wishes honored, and not leave it to confusion. Well, I should say it this way. It's both a directive to the people you've appointed to give them guidance of how to make decisions when you can't tell them, and which also is the side benefit of giving them the peace of mind that they're doing the right thing. And secondly, if anyone is disagreeing with their decisions, it gives them something to turn to and say, look, this is exactly what they wanted me to do. They took the time to put it in writing in their living will or their medical directive. I'm doing what they directed me to do. So, for all those reasons, it's important to communicate both through conversations and in writing what your wishes are. I think we can go to the next slide. So, one thing sometimes people ask, well, what happens if I don't have these documents? Maybe, I've even gotten a diagnosis of Alzheimer's. What's going to happen now? So it's only, you can always write up these documents unless you lose the capacity to have enough understanding of the document to sign it. So even with a diagnosis, if you have early Alzheimer's or the beginning signs of dementia, you can still sign these documents. And even if you have some memory impairment, if in the moment you understand the document, you understand who the people are in your life who you could choose to put into these roles, I still have those clients sign documents. But if you wait too long and you lose that capacity and you don't have that power, then the only way to do this is by filing in court, in probate court, to become a guardian or conservator for this person. And, you know, we do these documents in part to avoid that. We want to avoid going to court for a number of reasons. One, it's expensive. Two, it's time consuming. And three, if there's any disagreement about who should be in these roles, it can be a very messy process. And by that, I mean, if you think about when people use that term, a messy divorce or a child custody battle, I can't tell you it's terrible to see, but families really can get torn apart on that. Plus, they're spending tens of thousands of dollars on legal fees. So when you can avoid it, it's best to do so by planning ahead and having a power of attorney and healthcare proxy in place. Now, as I mentioned earlier, sometimes even having a power of attorney and healthcare proxy, you're not avoiding the need for guardianship and conservatorship. So there are certain kinds of cognitive decline. Well, let me put it this way. Powers of attorney and healthcare proxy work best when the person is declining and aging in a way that they're becoming diminished and their world is becoming smaller and they are agreeable and going along with the care that they need. They're accepting the help they need. Powers of attorney and healthcare proxies do not work well for someone who is has a kind of cognitive change in their brain where they are becoming paranoid and agitated and there are big mood swings, like something like you may be familiar with Lewy body dementia. It's a terrible illness, and you can have those kinds of symptoms. And these documents just won't work well for that, or mental health issues. I have a client right now who there's something slight going on cognitively, but they're a very bright person. They were an academic, and they are being scammed. And they just have a mindset that they don't see it as a scam. You know, they can come up with lots of explanations of why this is a great business deal. And a power of attorney and healthcare proxy are really powerless for that kind of case. And the only way to stop it is to get a judge to deem the person incapacitated and remove their ability to enter into contracts, make medical decisions for themselves, all of that. So, as much as you want to avoid it, because it can be problematic and expensive and divisive, sometimes it's necessary and it's the only way to protect uh, uh, a person who is putting themselves at risk. Um, let's go to the next slide. So, beyond advanced directives, the other big area of documents that are important to consider are wills and trusts. And these are documents lots of people are familiar with. Again, these are some of the tools in the legal toolkit to help people depending on what they need, and depending upon what they're trying to achieve. Next slide, please. So to start with, a will, most of us are familiar with a will, and its purpose is it states who is going to receive your property when you die and how are things divided. And it also names the person who's in charge. Uh, in many states, that person's called an executor. In Massachusetts now, we call that person the personal representative. If you don't have a will, your property will pass according to something called the intestacy statute. So basically, it works like your next closest relatives would get the will. And that can be fine. So if you're married and you have children from the same marriage and you die without a will, it's going to pass to the people you want it to. But if you, there can be really perverse results. Someone has had a partner for 50 years who they've loved and been close with, but they're not married, and they have their next closest cousins or their next closest relatives are their first cousins who they haven't spoken to in 30 years. That person dies without a will, the cousins get the entire estate, and that happens all the time. So a will can be a critical document, and you hate to see those terrible results where undeserving family members get an inheritance and the loving person who should be getting everything is disinherited. Um, there's sometimes confusion about what a will governs and what it doesn't. So it's another part, an important part of your estate plan is making sure that your will is consistent with the way you are holding your assets. So, one thing that's important to understand is a will only governs the assets you hold in your name when you die without a joint owner and without a beneficiary and outside of a trust. So, if my will leaves everything in equal shares to my children, but I've named my good friend Barbara as the beneficiary on my life insurance, my children won't get that life insurance. Now, maybe that's what I wanted, and that's all well and good, but when I talk to my clients, I need to see all of their assets, and we talk about their beneficiary designations and joint ownership. And again, this is about being intentional. And I've even had clients, who have wanted everything to go equally, and they thought that they handled their assets properly. Maybe they had, you know, part of their assets were three CDs that they own jointly with each of their children, and they have a will that says everything goes equally. But the years go by and they're declining, and they have to cash in one CD to pay for a repair to the house. They had to cash in a second CD to pay for their assisted living. And when they die, there's only one CD left with one child's name on it, and that child will get that CD. And maybe they're a good person and they'll share everything equally with their siblings. But as you might imagine, not everyone has that perspective. And so, again, it's important to be intentional and to think that through. And my recommendation is it's usually best to make your beneficiary designations the same as um, your will beneficiaries and to not pass things by joint ownership. And people sometimes do that to avoid probate, which is probate is a well, actually, but you know what? I'm going to hold off on that for 1 second. The other thing to consider in your will is, who are your beneficiaries, and are there any circumstances where it would be a problem if they received an inheritance directly? So, if you had a child who's disabled, or you had someone, your partner who might have struggled with substance abuse, whatever it is, a will might not be the best way of leaving your assets, because if you're leaving things to that person outright, they could cause a problem. In addition, you need to think about who is going to be the personal representative of your estate. Um, that often, in the same way I said it about the power of attorney, I would name one person at a time to avoid disagreement. You don't need to name a lawyer as your personal representative, and I usually advise against it. The only times when I recommend having a professional is if your children don't get along, or then it's better to name a professional because there's going to be a lot of fighting if you don't have you have beneficiaries who are in disagreement, or if you don't have kids and you're leaving things to charities, it might be a good idea to name a professional. Um, One other thing I would note to consider is I've had a number of cases, and this doesn't come up that often, but enough that I want to mention it, where my clients have named a friend in some of the important decision-making roles. That's their person who they really trust. And they've left in their will their assets to their family. And so the person, the friend that they named in this role might have done quite a bit for them while they were alive. And I usually would ask that client, have you thought about leaving that person something in your will? I mean, you thought enough of them to put them in these important roles. And I've often been surprised that my clients have said, I can leave them something. I didn't think I could. I thought I had to leave it to my children, or I hadn't thought about that. And in the same way, asking, do you want to include any charities in your will? I mean, I don't want to tell people what to do. That's not my place. But I want to at least ask questions so that it's something that's considered. Because, I've had a number of cases where, the person who did the most for them during their life was left nothing, and it just doesn't seem right to me. So, lastly, just to go back to that probate question. So, people are often confused that they think by having a will, they're going to avoid probate. Um, Probate is the legal process of authenticating the will in court. So a judge ruling this is your valid last will and testament. And secondly, the process, the judges appointing the named personal representative. So having a will, you can't just go to a will and go up to the bank and say, hey, here's my mom's will. She's died. Here's the death certificate. You can see I'm the beneficiary. I want to close out the account and take the money. The bank doesn't know whether that's the valid will. They have no way of verifying that. And what the bank is going to want to see is a piece of paper from the court called letters of authority that say this person is the personal representative so and so's will, and they are entitled to act in that capacity. We try to avoid probate if we can, because it can be time consuming. The process can take up to a year, and it can be expensive. So the way you avoid probate either by making sure when you die you don't have any assets in your sole name. So if you have a simple family where you have one child and you wanted to name that child as the beneficiary on everything, then that's a way to avoid probate. But more typically, the better ways to avoid probate are by using a trust, which I'm going to get to in a minute. The last thing I want to mention that you can do in a will is it's also the place where you can name who you would want to be the guardian of your minor children, or a disabled spouse or an adult disabled child. So again, you're naming who the personal representative is, but on top of that, you could say, if I die and my spouse is incapacitated, I want my sister to be his guardian and conservator. And the judge still needs to appoint that person, but the judge is going to look at your expressed wishes and give that a lot of weight in deciding who it should be. So it's important to also do that in your will. Let's go to the next slide. So here is a little bit more about probate. Um, Again, it's the process in the court where they decide, um, and they authenticate your will, validate it, um, and the court's deciding how to your assets are going to pass. So, in addition, the probate, if you have a will, it's validated and authenticated. If you don't have a will, then the judge is deciding based on the intestacy statute how your assets will pass. Um, it's also the although I'm describing the downsides to probate, the benefit of probate is it is an open airing of the last will and testament. So if there's any questions about the validity of the will, it's the place where you get a chance to object. So if there's been a will done in the final weeks of someone's life, the advantage of probate is if there's any questions about whether the person had capacity or there was some kind of fraud, that's where you can um, make your objection and potentially overturn a will. So, generally want to avoid it, but there are some scenarios where it can be a helpful process. Let's go to the next slide. So, for many of my clients, having a simple will is not enough. Um, and the tool that I find that's helpful for those clients is a trust. A trust is a legal entity in which one person, who we call the trustee, holds title or ownership to property for the benefit of someone else, the beneficiaries. So the trust is a set of rules of how you've indicated you want the trust assets to be used while you're alive, who they're to benefit, and in what circumstances they're to benefit the person. And then a separate set of rules of what happens to those assets when you die. So it can work like a will substitute. So if the assets are in the trust, the trust will direct who gets those assets rather than your will. And often when I do them together as a will and a trust, I'm writing what's called a pour over will that directs the personal representative to put all the assets in the trust when you die. And then the trust tells us what is going to happen with those assets when you die. Um, Trusts are used for so many different reasons. Um, I was just talking a little early, it can be used to avoid probate. So if when you die, everything is in your trust, or if the trust is named in the beneficiary, you can avoid probate. So you put your house in the trust, you can put your bank accounts in a trust, your stocks, anything can be in the trust. So that's a way to avoid probate. Another reason people do it is maybe you have a beneficiary who's vulnerable and you don't want them to get direct access to the money. Maybe they have an impairment where that make them vulnerable to be taken advantage of. Maybe they have an impairment where they make poor decisions. They might have substance abuse issues. So many, if you think about all the different things that make someone vulnerable, where getting an inheritance would be terrible, or the money would be disappear, having the money held in trust instead, and maybe it continues to stay in trust after you die, is the best thing. So with the trust, in those situations, you're leaving the money for the benefit of an individual, but someone else is in charge of it. That person's called a trustee. You might name another family member or a friend. Sometimes, again, it's a professional who you're putting in charge of that. When you're thinking about a trustee, it's similar to the power of attorney. You want someone who's you can trust, they're responsible, they're organized, and they've got common sense. All of those are things that are going to help them do a good job. Um, you can also, if someone has problems with creditors, you can keep the money in trust for them. People do planning for long-term care planning to protect their assets if they ever need a nursing home. Lots of different reasons. Um, there are both revocable trusts, which, as it sounds, you can change it, you can revoke it by the person who's creating it until they die. So, revocable is just like it sounds, it can be revoked or changed. An irrevocable trust cannot is one that can't be changed after it's created, with some exceptions. So, you create a trust that's irrevocable, you might retain the power to change the trustees, or you might retain the power um, to um, change the beneficiaries. So it's irrevocable, generally meaning you can't get the money back, but or assets back after you put it in there. But there may be some instances where um, uh, it can be changed. Um, I usually, in some situations, with my trust, particularly with my clients who don't have children, I like to include language directing the trustee to use the funds to maintain the person's independence and provide optimal care. Basically, it's a directive to the trustee, use this money only for me. Don't worry about what's going to be left over as an inheritance. And I want to get the optimal care. I'm not worried about how much money is going to be left over. So again, trusts are great documents. They serve lots of purposes for estate and long-term care planning. They're not for everyone. Just because your friend has a trust doesn't mean that you need one. So it's really matching up with what your objectives are. So one question that was asked, if someone's spending months of the year out of state, are forms completed at home in Massachusetts? Would they be recognized out of state? So generally, yes. So when I'm writing documents, I try to write them keeping in mind, having it witnessed and notarized, even if that's not a requirement in Massachusetts, because some states may require that. That said, my advice is if you spend 6 months out of the year in Florida, you would also want to have a Florida form power of attorney and healthcare proxy as well. You just have to be careful that the power of attorney doesn't include any language that says, I hereby, when the healthcare proxy for that matter, I hereby revoke any other prior healthcare proxy or power of attorney I may have signed. So, and that you don't create confusion by naming different agents in your Florida documents than you have in Massachusetts. It's just that for ease of use, when you're presenting a healthcare proxy to a provider in Florida, they have more typical language that they see and understand. And even the title, there are some states that call it a medical power of attorney, not a healthcare proxy. So if that's the case, you might have, it may be easier to use it if you have a document in that state that's called a medical power of attorney rather than a healthcare proxy. Um, let's move on to the next slide. So another document that I've started using for certain clients is called a care committee agreement. So over the last 10 years or so of my practice, I've had more and more clients who don't have children and or they don't have relationships with their children. And they also, a lot of these clients don't have a partner and they have had a, very rich community of friends and maybe more distant family members. But when we're starting a conversation about who they want to put into the role of power of attorney or healthcare proxy or trustee, they're worried that this is a really big request. They feel like they're doing something that's a burden to this person. One way we've come to address that concern is through this care committee agreement. And the idea is to formally designate a group of individuals who are important to the client, who are available to consult with them on their care and how they want to age. We're basically trying to formally create a support group, if you will, both for the client and for the people they're designating as their decision maker. And part of that is to alleviate the burden. So if you're naming your best friend as your healthcare proxy, they know that they're not alone. Um, Typically, the committee would include the client, their healthcare agent, their attorney in fact, a trustee if you have a trust, and a care manager, the social worker. And so when you're naming your friend as the healthcare proxy, and maybe that friend lives out of state, they know that if something happens, they have this support group who is available to help them make important decisions and also perhaps to delegate some of the responsibility. That's, the care manager is such an integral part of this. And Barbara and I have worked on this with mutual clients and some friends that, it is very empowering, and that care manager can be facilitating the discussion so that, and as someone, if a friend's out of state, they can jump in and go to doctor's appointments and report back to the group. So it's really, I found it to be helpful in providing peace of mind for the client and for the named decision makers and the proxy and the power of attorney, that we're all functioning as a team to help support the client and then the decision makers in ensuring that the client ages well and in whatever way that means to them. So again, it's not for everyone, but I've done this. I've lots of clients in these situations and it's worked uh, very well. Next slide, please. So just to speak briefly on financial planning. So one of the concerns for my clients is, how am I going to pay for my care if I become impaired and I need assisted living or I need to go to a nursing home? So the problem is this care is very expensive. Care at home, can be, thousands of dollars a month depending on how much you're getting. Assisted livings in Massachusetts can be $5,000 to $10,000. Nursing homes can be $15,000 to $20,000 a month, so it really adds up. Medicare pays for very little. At most, if you're in a nursing home, up to 100 days, but usually it's less than that. If you've had the foresight to buy long-term care insurance, which is insurance that'll pay for your care at home or in assisted living or nursing home, different settings. It is triggered by your needing assistance with activities of daily living, but you need to buy that when you're young enough and healthy enough so that it's not too expensive. For some people, was a great idea, but if you're basically if you're in once you're past your 60s, it's too expensive to get, and you certainly can't get it if you've already have a diagnosis that makes it likely that you're going to need care. So it's not something, once you get a diagnosis at Parkinson's, you decide to buy long-term care insurance. So you got to do it while you're healthy and young. Private pay is an option, and I have clients who are wealthy and are able to afford that. I mean, in Massachusetts, this isn't obviously true for everyone, but even clients who don't have a lot of money, if they were able to buy a house, in the 70s or 80s, the 1970s or 1980s, there's been a lot of appreciation, and you might only have $50,000 in the bank, but you might have a house worth $1 million, and that's going to enable you to pay for your care. Other than that, many of my clients, we discuss mass health planning. So, mass health is our state Medicaid program, and it will pay completely for your care in a nursing home, and it'll also provide a significant amount of care in your home. But there are very strict asset limitations, so and also rules regarding gifts. So basically, in order to get eligibility, you've got to prove that your assets are below a certain threshold, and you have to prove that you haven't given away your assets. So those rules are quite complicated. Um, there are both things you can do ahead of time to plan for mass health eligibility in the future, and even at the last minute, particularly for married couples, there are opportunities to do planning to protect the assets for the spouse in the community so she retains those assets for her own or his own care needs. The bottom line, if that's something that you're thinking about, I mean, this is part of planning ahead. How would I pay for my care if I need it in the future? It's a good idea, again, to circle back with your team and discuss this so you are being intentional and don't have an outcome that's not what you had in mind. Next slide. So, just in conclusion with all this, um, these are the important things to keep in mind: communicating with your family, getting organized, identifying the people who you're going to put into these roles, working with an attorney so they can help you think about which documents you need,